Good morning, Ms. Miller. Ms. Miller, good morning. You may proceed.
Thank you. May it please the Court, Christina Miller for the Commonwealth. This case is really about an application for a search warrant where the magistrate reasonably found that the facts and inferences would lead him to believe that items sought reasonably may be expected to be found in the location to be searched.
Doesn't this really boil down to whether the judge, the magistrate, is entitled to believe that the so-called expert testimony of the police officer? That seems to me that's the nub of the whole thing. If what the police officer says there's a basis for, and the magistrate is entitled to believe it, then it seems to me, at least, that there'd be probable cause to issue the warrant.
You mean his experience?
Well, what qualifies him as an expert in child pornography, in the child pornography area, this particular police officer?
Yes, he enumerated in his warrant.
I read it, but I'm asking
Okay.
you what in it qualifies him as an expert in the child pornography computer area.
That he stated that he had conducted numerous investigations of sexual assaults, including computer-related crimes. This is on record page 11. And he also stated...
So you think that the fact that he participated in investigations qualifies him? Because when I read the application, I was looking for some particular training and didn't see any.
He also listed his trainings on page 11 through 12 that included the sexual exploitation of children using computers and computer forensics. So there was a long list of his trainings as well.
And you cited the two federal cases that support your position, McCarty and Back.
Yes,
and
I would
where
also
warrants were issued on similar facts.
Yes, I would also cite, I sent a 16L letter citing this Court's recent decision in Kenny. Kenny also recognized the expert opinion of an officer who conducts these trainings, who sees the patterns, who knows through their training that a pedophile will keep their images, will secret them away. And in those sense, the magistrate could use that.
Well,
However,
that's what I'm looking for. So you say that in having investigated other people, he's qualified to say that these people who commit these type of offenses secrete these materials and keep them.
That's correct. Okay. That's correct. But I would say, while the magistrate was allowed to rely on that, it is certainly not the only evidence. I would actually disagree with the lower court judge's conclusion that the only evidence, which is on record page 121, the lower court judge said any inference that the defendant had child pornography in the storage locker could only derive from the detective's opinions. I would disagree with that. One, it is not the only evidence.
What else is there?
The evidence we have is that the defendant is a convicted pedophile. He was convicted in Arizona of soliciting children for sex. He also admitted to possessing child pornography in Arizona, and he was convicted of 17 counts. 3 of those counts are sexual.
Miller, that frankly doesn't help me. I mean, I know that he's a convicted pedophile.
Right.
Am I correct that the Commonwealth's position is that if you have reason to believe that somebody is engaged in, not previously, but engaged in Internet child pornography, that a search warrant based on an expert view, assuming that we agree that this is an expert view of the police officer based on his experience, that any place, any location over which the defendant has control, either owns, occupies, or has control, like a storage locker, can be searched. Is that the Commonwealth's view?
It would be the Commonwealth's view as long as it's reasonable. I mean,
well, it's not reasonable because what I've got here is we've got the Commonwealth believing that this person is involved in Internet child pornography. You have an expert who says, I believe that these kinds of people store, keep, maintain, don't destroy. You may even add to that, as either in this case or the other cases, helpful cases to which you referred us, that even if you're using a Boston Public Library computer, they use other computers. Therefore, we can search any place because we don't know that there are computers. We don't know what he has in a storage locker.
I would add to those facts that, in fact, we have information that's enumerated in the warrant that he has 5 computers. And then he lies about having computers.
That's
Well,
all
but
that's
I'm just
interesting,
trying
but
to
how
fi-
does that help answer the question? What if this was not a homeless person whose only place was a storage locker? What if this person had an apartment in Boston, had a home in the suburbs, also had safe deposit boxes? Same evidence. What can you search all of them because
Even
this
if you
materials
don't-
could have been anywhere?
I would say yes, in the sense that if there's a connection, if there is a reasonable connection with a computer either in the home,
And what
such
is
as
the
Kenny,
connection?
What's
What is
the
the
connection?
such as Kenny.
What's the
What's the
connection?
connection?
I'm
I
sorry,
mean-
in this case or
Yeah,
in
you
the
knew that
hypothetical?
he had 5 computers. You don't know where they are?
We
Well,
know
no,
that there are
excuse me,
2
wasn't-
computers at the repair shop.
Yes, we know
Okay,
that.
so then we think, well, where are the 3
No,
other
but
computers?
all you're telling me is, as you can search any place, if you, I mean, one limiting thing may be, which I frankly didn't see in your brief, if you know that somebody has more than one computer, you can search any place to find out where that computer is and search that computer. Am I correct?
Well, isn't this case a little
Helen,
narrower?
can you just answer that question?
As long as there is a reasonable inference that it would be there.
Well,
So is it
no, wait,
reasonable that a person would keep the
But
computer in their home?
that's not this case.
That's what I'm trying to
Right,
say.
This
I agree,
case is
but I'm
if
just
you
answering the
accept
hypothetical.
the affidavit of the police officer, accept the fact that he is an expert, if you do that, then you've got his saying that these things are often in safe deposit boxes and storage facilities.
Correct.
Yeah,
That
but
is
that
correct.
means that
But we also have more here.
because it's the police officer is not saying, I know it's in this storage. In fact, if we agree with you here, if a police officer says, and I have no doubt that the other police officers will, namely, I don't think that this is a police officer, I think this is based on his real experience, that any place where there's reason to believe that there's a computer, any place where there's reason to believe there's a computer, can be searched.
No, but in this case, there
Hold
are
on, can
indications.
you just answer that? And I'm not asking about this case. I'm asking about what
The
the
hypothetical.
rule is. Any place, because the assertion is people who engage in internet child pornography store material. They may use, they are caught using a public computer, like Boston Public Library, some other public library. A police officer comes in and says, I know they store, I know they keep,
Correct.
right? I know they keep those in storage places or in their cupboards or whatever it is. So that means that you can go and search any of those places, correct? I mean, that's the Commonwealth's position.
If it's reasonable, depending on the place, I mean, it does depend on other things. So
Well, what are the
I mean,
other
my
things?
answer would be no, in the sense that, you need a reasonable tie, something using your
Here, in
common
this
sense,
case,
using the normal
there
inferences.
are indications that he
So-
used photos having sites which allowed him to transfer images from a public computer to a personal computer. That's in the affidavit. And I think that's something here that ties this to computers and to, because he has a transferability.
Well, and
from
here,
computer to
obviously,
computer.
given the hypothetical, I agree, we have more than the hypothetical.
What you have
but
here,
answering the
what
yes,
you have here is he has only one place to store anything.
That's
And
correct.
that's a storage locker. Because
And
he's a
then he-
homeless person, you've established that. He's actually admitted, well, in any event, he has no car, no other place.
Correct.
So
But-
that's why this case is okay.
Right, and in Kenny, the case is okay there. I mean, we don't know that he has computer access in his home in Kenny. We only know in Kenny that he has a computer, but there is nothing in that case that ties his home computer to use of the internet. Because when you look at the application for the search warrant there, the application says that they tied the computer pornographic images of children to his work computer. It was to an email address, right? It was his use, but it was actually tied to his work computer.
It
but
was
the
read on
reason-
his work computer.
It was Well, around the time that the image was sent, right, there was an email clip that he was using his work computer using that.
Using his
email
home
address.
email. It wasn't a work email address, correct?
Correct.
Well, why would
Well, that
But
at
it was
least says,
registered to his home. But there was no
Correct.
direct proof that he's accessing the internet in his home.
well, except that people who have home email addresses tend to have a home computer. I mean,
It could be, but that's the reasonable belief in that case. There's no direct proof.
We can't decide all cases from this case. It's just like every case where there's a search warrant. It depends on the particular facts in the case. This will depend on the facts in this case. The next case will depend on the facts in that case. We can't make a blanket rule one way or the other about computers and child pornography.
But the interesting thing here, I would agree that the court can really make clear is that computers, and that's what we're really talking about, is computers are different. Computers are different than drugs. Computers are different than tangible items.
Why?
Why aren't they just storage places instead of file cabinets? If you were looking for records of something, they'd be in a file cabinet today. They'd be in a computer.
That's true.
That's all
but,
it is.
But we're talking about the lower court was requiring direct access, proof that this defendant used computers at the search location.
But we've never
and that's
required
clearly
proof
wrong.
beyond a reasonable doubt to obtain a search warrant. I mean, I don't see why this case is any different than when the police go in with probable cause to believe that there's going to be evidence of some white-collar crime in a file. They don't know it, but there's probable cause. Where else would you put it?
Well, in some ways they're the same. In some ways they're different in the sense, I was just saying in drug cases, we're talking about a tangible item. Here we're talking about images that can be saved in the internet and
but
then
they can be
accessed
saved
by Wi-Fi, accessed in numerous different places. You can't have drugs at your work and then access them at home. And that's the difference. Computers are different. They can
that's why I'm asking you, and I understand Justice Cowan's point, and I'm not suggesting that we're doing a blanket rule, and I am focused on the facts of the case. But I want to know what makes you've now just said computers are different. You can access them anywhere. And are you saying that as long as you know that it's a computer, if you have reason to believe that the suspect has a computer someplace, you can go to that place?
Yes, yes. It's similar to, I use this as a very rough analogy. Flight, for example, in here there's sort of a general rule in our case law, you need flight plus. So here I would say you need knowledge that there is a computer, right, and that the reasonable inferences that where it would be. And those are the two requirements.
Don't you, you don't need to go that far, do you? In this case, in that you've got him lying about computers, you've got the fact that he's homeless and has no other place of storage.
Correct.
So you
Oh,
really
yeah, no, I
don't
agree.
need to go as far as so
I agree, but I was just saying in the hypothetical, we
Oh,
don't.
well, it's
we
helpful,
have more
it's
than
helpful to know because
Correct. We do have much more than that. We have him. He's purposely covering up the fact that he has computers.
And actually
that naturally leads.
Actually, here he has two places to store his computers. One is the locker, and the other is the repair shop where he's left two of his computers. But he's lied about leaving it there. He gave an alias. He ripped up the receipt. So there's
Exactly.
more than sufficient probable cause to look at the two computers in the repair shop. It would seem to
Exactly.
me.
I would agree. I absolutely.
what is there? This is a factual issue that I couldn't. How did the police find out about the storage locker? Is that in the affidavit?
It's actually not in the affidavit, and to be honest, I'm not entirely sure about that. I think there was some mention of it by a witness that he may have a storage locker, and I think
by
it's
the Huggins
in this
or Higgins
town.
or something?
But that's I think he has a storage locker in Brighton, but
So
there
from
was
that we
no
could-
evidence of that in the warrant.
we have also assumed in some of the questions that because he's homeless, he only has one place where he can store things. We don't know how many places he has where he can store things, right?
No, we don't know. There could be other places.
But if he had another
but it's not
storage
in the-
locker,
it's
there
not in
would
the
be
affidavit.
probable cause, I suppose, to look in that storage locker as well.
I would agree.
So
on the
it gets
facts.
back to once you know that there are numerous places where he might have a computer, even if you don't know he has a computer there, you can go search those places.
Yes. as long as it's reasonable that a computer would be stored there. I would agree. I mean, for
A computer
example,
can be
here,
stored almost anywhere, right?
well, for example, here, we have Mr. Hutchins, who's his friend, right? And the friend says he stays at my place for, a couple hours, and I leave him alone in my house. But he doesn't, I don't know what he does there, but he doesn't leave anything there. Can we then search Mr. Hutchins' home? I would say no. We can't. I mean, even though he's been there alone, this is, and he could store computers there, there's not a reasonable basis that he would keep the computers at his friend's house when we don't really have any evidence. Now, if the friend said, oh yeah, I let him keep some things in the side room, then I would say yes. There's a reasonable belief that the items would be stored there.
Thank you, Ms.
Thank
Miller.
you.
Mr. Saiger?
Good morning, Your Honors. May it please the Court. Kenneth Seeger for the defendant, Mark Anthony. We're discussing this issue about whether there is a factual nexus between the criminal activity and the place to be searched, the storage locker. And I would suggest that it's worth noting some language that's found in a few of the federal cases that have analyzed this issue. And it's the idea that to permit a search warrant that is based on opinion of the officer and the, quote, self-avowed expertise of the officer, and to permit this without an additional...
What do you say then about the case of Commonwealth versus Fenderson, where the police officer said he had learned from past investigations that dealers often use safe deposit boxes to hide narcotics proceeds to avoid detection by the police, and a warrant then properly issued to search several safe deposit boxes? But isn't that the same thing that you're just criticizing?
Well, in Fenderson, no, because in Fenderson you would have an additional factual nexus, because in Fenderson you had wiretapping, electronic surveillance that the defendant in that particular case was involved in drug transactions.
But here you have prior convictions, and you have right when they arrested him on the warrant, he was looking at, I think, something on the internet that would indicate the same thing.
He was not looking at illicit images on the internet. There was some language that the officer observed, but there was no indication that he was looking at an illegal image. In Fenderson, the police executed a warrant, and they found cache of drugs, money, the safety deposit keys, all in the same place, and that, combined with their surveillance that the defendants had been engaged in drug transactions and monetary drug transactions, that it wasn't much of a stretch for the officer to conclude that that the safety deposit key was related to the cache of contraband, which was found right there. And in the present case, the defendant wasn't found with any contraband. And just the fact alone that there was a prior conviction, I'm not certain, Your Honor, that it was for a pedophile. It was a sex-related offense, solicitation of minors. I don't believe that there was a conviction for a pedophile offense, but be that as it may.
But part of his probation, wasn't a condition of his probation that he not use computers?
I'm not certain, Your
I
Honor.
thought that was one of the conditions
have
that
to-
was mentioned, and so they caught him using a computer in violation, which would connect him to the crime, this seems to me, in some way.
Well, the very fact that there is a prior conviction would not suffice to create probable cause
No, I'm not suggesting
to
that
search
it
a
would.
particular place.
Not
Just
suggesting
as the fact that a crime may be committed would not be sufficient to create probable cause for a particular place. Now, this is a case, and it's just what a few of the federal courts have been worried about, that you have an affidavit which is based on opinion, and to allow this kind of search warrants is virtually an open invitation to automatic searches based on the officer's opinion.
Do you have any cases from any jurisdiction that support your line of argument?
Well, there's the case, it's a federal case, a district court case in Maine, United
Judge
States.
Hornby's case?
I'm sorry?
Judge Hornby's case?
I know it's United States versus Guay, It's a case in Maine, and the court did not find.
You cite that, don't you, I think?
I do, Your
Yeah.
Honor.
But the expert opinion, as you call it here, is very narrow. It's just that persons such as the defendant who have a track record in soliciting and trading in pornography keep it.
He doesn't provide a single example. This,
He's trained in this area, has experience in this area. This is really not earth-shattering stuff.
Yeah, it's really common sense.
For someone who's been involved, what's he supposed to, there are 14 cases in which I have seen this happen.
but it's, well, that would certainly be a much more valid opinion.
what my
if
instructors
there was
at the
some kind of
school
track record. But I understand where the court is going, but it's still just opinion and self-avowed expertise.
But that's one part of this affidavit. You have him lying about, and these, since these are gotten over the internet on a public library where they could not be downloaded, they would have to be stored in some other electronic device. This all seems very rational and practical. And it seems to me the only, and therefore there would be evidence of this crime in other media, in other devices. Seems perfectly logical following the.
I would respond by saying that any factual nexus in this case, based on prior conviction, prior internet activity, and so on, only goes to one place. It goes to the library computers.
No, it doesn't. He has a, well, it may. You say it only goes to one place, but the opinion was that people tend to download and preserve. And since you can't do it on a public library, that media will have to be transferred in some other way. You can transfer it with a phone. You can transfer it with any other data device to another computer. He also was caught in his pocket with a whole list of websites and places to download and trade pornography, suggesting this is something he frequently does.
Mr. Sager,
But it would be, but you still need a nexus to that particular storage locker.
Well, that's a different question. We're saying, question number one is whether or not there's likely to be evidence of this type, other computers, other storage devices, other photos that he has preserved or downloaded. I think the answer is yes, there's likely to be evidence of this type, which is evidence of the crime. The next question is it likely to be found in this spot? Right? Those are two separate questions.
I think that with the issues that we're talking about, the computer technology that's available, internet technology, it shouldn't lead the court to that conclusion, because ultimately, at the end of the day, the police, whatever technology is involved, very sophisticated internet technology, ultimately the police are going to need to search a particular place, a home, an office, a storage locker, and essentially the Commonwealth is attempting to carve out an exception. They're saying, well, you can store it someplace else. Therefore, there's probable cause that it's in a storage locker, wherever he may,
Well, I'm not
have
suggesting
it.
there's probable cause to search anywhere the person may have ever stored anything, but in this case, you have evidence of one place, a storage locker. You have evidence that he gave a false address in connection with a storage locker. You have evidence that he owned 5 computers but denied he owned any computers. You have evidence that he put 2 into a repair shop under a false name. I mean, you have a whole variety of things that suggest this person is trying to conceal the fact that he has computers, and evidence that, in fact, these are the kinds of devices that a person engaged in this conduct would use to store the images. And there's only one place that they are able to establish that he is likely to store them.
I would suggest that the ultimate conclusion that there's only one place he can store it, and I would make an analogy to a few of these drug cases that have been cited by the motion judge, Commonwealth versus Smith and Olivares, where the courts have held that it goes towards this argument that he's homeless, and therefore it must be in a place where he has the ability to store something.
Securely store something.
But the mere fact that a place, the place to be searched, is the defendant's residence, that fact is not sufficient to create probable cause. So this argument.
Mr. Sager, go ahead.
Well, going back to the police officer's experience, did he tell us, I can't recall, how many years of experience or months or whatever he had looking into pornographic and pedophile cases?
I know that he detailed his training and
Yeah.
coursework and experience in detail. I don't remember how long he had been involved in that particular type of
Okay, so,
investigation.
but your answer is there is some information that A, he had training, and B, he's had some experience in this. So this sort of detracts from your, well, self-avowed opinion. I mean, all
Would it-
experts,
I-
all
I would
experts are
suggest
people with special knowledge give opinions. The question is, how trained are they to, you know, give such an opinion? It appears he had training and experience
Well, it doesn't appear to be
in a
not
field
one
that's
single
not
example.
rocket science.
Mr. Saiger, may I ask you this, and it would be helpful for me to know which main case you're referring to. I think it is Judge Hornby's case, and it's United States against Grant, and it's certainly the case that the judge in the Superior Court relied on, describing it as that the affidavit created probable cause to search the defendant's house for child pornography based on two activities of two Internet access accounts, which were directly traced to the defendant at his home address. I've read Grant pretty carefully, and I don't believe that that's what Judge Hornby is saying. I think at issue in Grant was how could you tell that it was this individual who was using a particular Internet account?
Well, I think it's important to note that in Grant...
Can I just finish? And so, but what Judge Hornby seems to be saying is once you can link the person to an Internet account, he then says, you know, based on a fair probability, and he sets out the correct standards and says these are no different than others, discounting the possibility that another individual was using it, you know, he assumes that you could then go to the suspect's house because you're linking the account to him. And I think that's obviously, regardless of whether it's a homeless person, once you have reason to believe that this person is engaged in Internet child pornography, why can you not search where you think there might be a computer?
Well, I think it's very important to note that in Grant and all these federal cases from various
Yes.
circuits,
Most
that-
of which I've read, at least the ones you drew our attention to.
and additionally, Commonwealth versus Kenny, which was recently decided, the Internet activity is traced to the home, to the defendant's home. And it's like tracing a phone call. And it wasn't much of a stretch to conclude that the illicit images would be in the defendant's home on his home computer, because the activity is traced directly to there.
Okay, so if you agree it's not much of a stretch to believe it's on those defendants' computer, why is it much of a stretch to believe it's on this defendant's computer?
Because any Internet activity only goes to one place. It goes to the library computers, and it doesn't go anywhere else.
But he can transfer it, as Justice Cordy indicated. And he had the means of transferring, I mean, indications that he was transferring it in his pocket.
That would mean that he would have, if he has the means to transfer it, that virtually is taking the idea of this type of technology and giving the police the license to search any place.
No,
where it
search
might be.
his computers, this man happens to have 7, so
I-
that they know
Or
of.
someone could send me an email with an attachment. I might send it to someone else. It's on their computer, and they can search that home.
I think a lot of this is colored by the fact that this defendant is homeless, so that it's logical, based on everything in the affidavit, to say a person in these circumstances, which are unfortunate, being homeless, if he has this kind of stuff, is going to put it someplace secure. And in this case, that's the storage locker. And he's obviously reasonably adept, some would say very adept, at computer technology. I mean, he's going in the library, you know, using them, you know, probably got 2 email addresses, as I recall. Clever enough, but, you know, trained enough to transfer material from one thing to another, et cetera.
I would suggest that, as the motion judge found, that any conclusion that anything might be found beyond that library computer requires
No, I mean, at a
reliance on
certain,
opinion.
point, you cannot stretch that nexus beyond a certain point. You couldn't, for example, go seize a computer in his sister's house because, well, maybe he's got something on her computer. But here, the storage locker, the repair facility, I agree with Judge Cowan, is a clear cut. But the storage locker is front and center, is this man's kind of substitute room like all of us have in the house where we keep stuff.
As Justice Botsford pointed out, there is no information regarding that storage locker at all. There's no information about how the police found it. There's no information that witnesses saw him go there or transfer images or store something there. There's simply no information about it. When you read the affidavit, and as I did...
We're talking probable cause, not proof beyond a reasonable doubt.
Well, correct.
Are you suggesting, this is going back to something Justice Cordy asked, that somebody with a modicum of experience in this area, that it's without more definite information, it's not a reasonable, we can't accept that someone with experience could come to the conclusion that people who view pornographic materials tend to store it? You say that's really not a reasonable thing, that's just self-avowed opinion?
It requires the assumption that there was a collection somewhere. And,
It's just really common sense. I mean, in the old days, they'd go find, before we had the computers, they'd go find storage of, zillions of photographs or magazines or, those kinds of things. This is just the modern way of doing it for some people.
But it's unlike many of the drug cases where there was certainly probable cause to believe that a cache existed in a certain place based on transactions.
Drugs are different. Drugs are tangible. These computers and images are somewhat ethereal. But anyway, we'll struggle with it.
You will.
Thank you, Mr.
If there are further
Sagan.
questions, I would address that at this point. Thank you, Your Honor.
Thank you.